The second hearing, or second argument that's scheduled for today, May 24th. And this is case number 21CA0052-M, State versus Bell. I'm Judge Theodosio. I'll be presiding over the arguments here today. Joining me this morning is my colleague, Judge Donna Carter, and my colleague, Judge Jennifer Hensel. So we want to welcome everybody. This is the first time we've had this many people in the courtroom, I think, so this is exciting for us. It's nice to see people interested in the process. So the way the arguments proceed is each party will have 15 minutes to present their argument to the court. The appellant may reserve up to 5 minutes for rebuttal. Attorney Sheldon, we have the time on the clock, or the clock on the TV there. I'll also remind you, if you let me know how much time you want to reserve. You know, as you get close, I may interrupt you and just let you know that.
Thank you, Your Honor.
The arguments are recorded and posted on the court's YouTube channel, so it's important that everybody be quiet during the arguments, and that the attorneys stay at the podium and keep your voices up. We do not use minors or children's names during the argument, so refer to them if that's the case here, in some other way, initials or otherwise. Other than that, I can assure you that Judge Carr, Judge Hensel, and I have read the briefs, and we are prepared to proceed if you are. Attorney Sheldon, will you be reserving time for rebuttal?
Yes, Your Honor. I'd like to request 5 minutes, if I may.
So keep an eye on the clock up there, and I'll also let you know as you get close to the 5-minute mark. Thank you, and you may proceed.
Thank you. May it please the court, Judge Theodosio, Judge Hensel, Judge Carr, my name is David Sheldon. I represent Gary Bell in this appeal. This was a trial before the court, as this court is aware. I had been representing Mr. Bell for 6 months on the co-counsel before I was discharged, and then Mr. Bell retained Attorney Ray Jones, and in less than 4 weeks, Mr. Jones took this case to trial. The issues in this case, as I've outlined them, are the sufficiency of the evidence, the manifest way of the evidence, and trial counsel's ineffectiveness in representing Mr. Bell. This case involves a married couple. Gary and Carolyn Bell had been married for 29 years. They were living in Medina County in Montville Township at the time. And as you know from the facts, these two never had a history of violence together. Very loving couple. Carolyn loved Gary very much. She said that in her testimony before the court. Gary loved her very much. No incidents of domestic violence ever. Gary testified at trial that he never laid a hand on his wife in the entire time that he had known her. And I think the evidence shows what happened in this case. Gary had taken over as a manager after his business had been sold to Vans Tires. And he took the business from, I believe it was $700,000 a year to over $3 million a year in sales. He was a very dedicated employee, but there were stressful situations. He was working anywhere from 60 to 80, 90 hours a week. And at the time, there were accusations being made by the new owners of, I think, Gary causing people or employees to leave, things that he'd never heard of in his entire life. He was under a lot of stress. He had taken his Shelby GT500 Mustang to work that day, and when he left work late, it was around 8, I think, or 8:30 when he left, and Carolyn thought he'd be home earlier, around 6 or 6:30 for dinner. She got some Mexican food. She indicated she had a couple margaritas, was waiting for Gary, and Gary took a different route home that night, and it kind of surprised her, and Carolyn was aware that Gary had hired a new employee named Ashley. And I think Carolyn was a little suspicious of Ashley at his place of employment, but Gary will tell you he's been faithful to his wife his entire time that he's been with her. And Carolyn saw him taking this different route off of Route 3 coming up south instead of, or coming up north instead of south. and he was down by 76-224, and there's a hotel there, and, you know, her mind went haywire, as she testified to. She had these thoughts that he was cheating on her. She pulled out of the driveway to go see where he was at, and that's when Gary turned in the development, was pulling in to the development. She turned around, followed him in the driveway. She met him at the car, he got out, and they had an argument. And this argument carried into the kitchen, as he indicated, and it didn't last very long in the kitchen. They argued more outside, and Gary was upset because Carolyn thought he was cheating on her and having some kind of affair or something with this Ashley. Gary adamantly denied it. He knew that Carolyn had had some drinks. He said, I've had enough of this. I'm sequestering myself in my bedroom. And he walks down the hall and goes into the bedroom, and he was ranting and raving, as Carolyn said. She heard him through the room, ranting and raving, and there's a dispute in the testimony whether or not Gary knew that Carolyn had gone into her bedroom and shut the door. And that was a long part of the cross-examination of my client. And Gary said, did I think she went in the bedroom? Was that her normal course? Yes, she goes into the bedroom, and that's what she does. But be that as it may, Gary was frustrated. He was looking in the mirror. He's going, I can't believe this. I do all this for the family. I'm being accused of this. He's ranting and raving, and he reaches for the gun. I believe it was a 9mm or 40mm. 40 caliber. I can't recall. And he didn't have a lot of experience with this gun, and he took it out, and he said, he was going to kill himself. And he put it up to his head, and he said, I was a coward, I can't do this. And out of frustration, he turned and pointed the gun and pulled the trigger, and it went on a downward trajectory, as you know from the evidence in this case, and went through his wall of the bedroom that he was in into the adjoining bathroom wall, and lodged in a stud 9 inches below, or 9 inches above the floor and below the toilet paper holder in the bathroom. Now, at the time this happened, Carolyn...
Just for a second.
Sure.
Let's just pause. I don't mean to interrupt you, but
No, it's fine.
we want to make sure we're paying attention. Make sure all your phones are on silent, please. All right. You may continue.
But out of frustration, he turned and pointed the gun, and he pulled the trigger. And he admitted to the police during the interview subsequent there, and there's a video interview, and I would ask you to watch it if you haven't. But he said to the police he had lied about how the gun went off. He gave a description how he slammed his hand down on top of some socks, and the gun went off, and that it was accidental. Now, part of what he told was true about it being accidental. Not the first shot. The first shot wasn't. He just turned, pivoted, and pulled the trigger and shot it downward into the stud of the bathroom wall. And Carolyn, she testified, she was in the garden tub this whole time. That's where she goes when she's in a stressful situation. And that garden tub was on the opposite side of that bathroom where the door was, and this little bathroom was for the toilet. It was just a toilet in there. She was on the other side, she's in the garden tub, and that's where she said she went. This bullet that was fired by Gary intentionally on a downward angle could have no way possible have hit his wife. No way. She was not in the bathroom. She would have had to been curled up on the floor, wedged between the wall and the toilet paper holder and toilet for him to have harmed his wife. Gary had no idea where she was when he fired that shot. He had no idea. Now, the state says, oh, he knew she was in the bedroom. Well, Gary says, I absolutely did not know she was in the bedroom. Did I assume she had gone in the bedroom? Yeah. But the point is, they have the burden of proving he knowingly attempted to cause physical harm to his wife when he pulled that trigger. In no way is there any evidence in this case that he had the mental state of mind to cause harm to his wife. No threats were made by Gary towards his wife while he was in that bedroom. There's no evidence he ever made threats to his wife in their entire 29 years of marriage. This was a moment of stress, and it was a stress release valve for Gary when he decided not to pull the trigger against his head and point it and fire it into that bathroom wall. And
Counsel, let me just interrupt, because my understanding wife had indicated she was in the bedroom, and then when the first shot went off, she ran and hid in the garden tub and called 911. And
that,
you just indicated to us that she was in the garden tub to begin with. Isn't that what she told the police, something different?
yes, Your Honor, she did initially, and then she, at trial, she said she recalled because of the stress of the moment and her thinking at the time that she was so hurried and having to tell the police what happened, but she recalled that actually she was in the garden tub the whole time when both shots were fired, and it wasn't a pause, as the state's going to argue. It was bang, bang, 2 shots, and that's what her testimony was.
And again, she told the police there was a time difference between, there was a gap of time between the first shot and the second shot, is what she initially told the police.
She did, Your Honor, and again, she's in her mind is not right at the time. She's had 2 margaritas. She's trying to recall the facts at that time, and people recall more events during a trauma situation later on. Everyone knows that.
What about the son's testimony? Was it consistent with a reflex shot?
Well,
Because
Your Honor,
he heard the shots too.
no, Your Honor, actually, he testified that it was 1 shot.
Oh, okay.
He testified at trial that it was 1 shot, and my argument was that it was so quick, those 2 rounds were so quick, he thought it was 1 shot.
Okay.
And I think that corroborates the bang bang, because he only heard 1 shot. And he's in the bedroom right next to Gary's when Gary pulls that trigger. So how could he not hear 2 separate shots if there's a delay of 7 or 10 seconds, as the police and state would like this court to believe? He would have heard 2 shots if he's that close. He heard 1 shot, and that's consistent with a quick discharge of 2 rounds. And as the court knows, our expert, Ray Barnwell from South Carolina, firearms expert, he knows this reflexive action that Gary had after he pulled the first round. He said his arm moved up and to the right, and it was a reflexive action because Gary's inexperienced, and he pulled the trigger accidentally a second time, and that shot was on an upward angle, and obviously the court knows where that shot went. It went through the master bedroom wall, through the bathroom wall, master bedroom wall, and then exited through the glass slider in the master bedroom and out into the woods.
Attorney Shelton, I'm going to stop you only because if you take a look at the screen, you're into your rebuttal time a little bit. You can continue going if you'd like, or you can reserve the balance of your time. Either way.
I'll thank Your Honor a little bit more, but I think the significance in this case is the state had to prove beyond a reasonable doubt that Gary knowingly attempted to harm his wife with that gun that night. And there is not a scintilla evidence that, number one, Gary ever intended to harm his wife that night when he pulled that trigger and when the second round went off accidentally. And there's no evidence that Carolyn Bell, and I pointed out this House Supreme Court case of State versus Mills, was ever in the line of fire, that she ever heard a bullet go by her, that she ever sensed or felt a bullet go near her. She was nowhere near either one of these rounds when they were fired. And something for the court to think about. If Gary Bell really wanted to hurt his wife that night, why does he only fire 2 rounds? He leaves a round in the chamber. They found the round in the chamber in the gun. And it's because he didn't intend to harm his wife. He only 2 rounds were discharged. He had a full magazine they found, didn't fire more than twice in this case, and neither round was intended to harm his wife. And there's a lack of evidence, sufficient evidence of this in this case, that he intended to harm his wife. And a happy couple like this, one day he doesn't just come home and decide to harm his wife. And obviously I argued also the manifest way of the evidence obviously points to his innocence in this case. I'll let the court review the assignment of error in terms of Mr. Jones's effectiveness of counsel. Again, I don't believe he was effective. I think his closing argument was 3 minutes. I know everyone's going to say, well, that's trial strategy. It's not a lot of trial strategy when a man's looking at mandatory imprisonment, and he's got 2 firearm specs. Thank you.
All right, thank you for your argument. You'll have 3 minutes and 2 seconds for rebuttal. All right, counsel, you'll have 15 minutes.
Good morning, Your Honors. May it please the Court, I'm Vince Bellucci with the Medina County Prosecutor's Office for the appellee of the state of Ohio. The undisputed facts of this case are that after arguing with his wife, Carolyn, and while in a rage, Gary Bell twice fired his pistol into a room that he knew his wife, Carolyn, was inside. so doing, he twice knowingly attempted to cause physical harm to Carolyn with a deadly weapon. Bell attempts to confuse the facts and the law in this case when both are really actually quite simple. He splits hairs by stating that he didn't aim his pistol directly at Carolyn, whatever that means. He just aimed and fired into a room that he knew for sure that she was in.
Is it undisputed that the first shot was towards the floor?
Well, there were two shots, two bullet holes in the spare bedroom that he was in. One was a little bit higher, one was a little bit lower. One was about, I think, 59.5 inches off from the floor, and then one was in the 30s. So one's about 5 feet high, one's about 3 feet high off the floor. And then...
Counsel, I'm going to interrupt you if you don't care, because that's not my understanding. Maybe I just misread it. I thought that it was much lower than the 30 inches. I thought that it came back that it was...
That's the one that it hits in the bathroom is about 9 inches off the
Well,
ground.
there were only two shots, right?
Right. So one was recovered, one slug was recovered, one was not. And so one was clearly on a downward trajectory, went through the wall, went into the 2x4 stud in the bathroom, and so it ends up in there about 9 inches off the ground once it gets in there. The second one, presumably the higher shot, was never recovered. So if he's just venting, as Mr. Sheldon says, I'm wondering, and the jury the judge was clearly wondering why he wouldn't just fire, I don't know, into the ceiling, into the floor, into literally anywhere else, any other wall, anywhere else, a dresser, I don't care, anywhere but into the wall that he knows is abutting the room that his wife is currently in, as they're in the middle of a very intense fight. Bell notes Carolyn's testimony, that she knows Bell loves her and would never harm her. That's a very small part of her testimony, and if you look at what she said, the totality of what she said to the police and what she said at trial, it's actually pretty compelling in the other direction, Your Honors. Carolyn's statements on that day certainly fly in the face of that sentiment, and also most of what she said at trial flies in the face of that sentiment. If Carolyn didn't think her husband would harm her and didn't think she was in any danger, then why would she call 911 for the very first time in her life? Clearly, Carolyn thought she was in danger of being harmed. Carolyn testified that she was, quote, traumatized when she heard the shots. Carolyn testified that she believes Bell snapped, it's a quote also, and shot his gun out of anger. Carolyn testified that she was scared and didn't know what Bell's state of mind was. None of this testimony is the testimony of a woman confident that her husband is never going to harm her.
Was the 911 call admitted into evidence?
Yes.
Okay, and what, if you recall, what did she indicate on the 911 when she connected with the operator?
She indicated that she heard a shot and that it was her husband that was shooting.
So she didn't indicate he was shooting at her, she just said that she heard her husband shooting?
Yes. Bell's own testimony in trial was, it added compelling evidence to the state's case. Bell admitted that he argued with his wife Carolyn and went into a separate bedroom, ranting and raving in anger. He testified that he knew his pistol was loaded. He admitted that he intentionally fired the pistol through the wall, and admitted that he knew the rounds went toward the master bedroom where his wife was. He testified in no uncertain terms at trial, contradicting what he said to police, that this was not an accident, that he lied to the police when he told them that it was an accident. That's what he testified at trial. He admitted on cross that in his interview with police, he said nothing about suicide or about the gun being for him. First time Bell mentioned any of that was at trial in his direct examination. Bell even admitted that he changed his story after he received his expert's report. So after the expert says the first shot must have been intentional, and the second one was accidental. Well, now I better change my story. Oops, I told the police the whole thing was an accident. Now it's intentional. The first shot was intentional, not the second. Okay. So that's what his expert, Mr. Barnwell, said. And there's plenty of problems with the expert in itself. Mr. Barnwell admitted on cross that his opinion relied entirely upon his viewing of Bell's interview with police, and specifically Bell's statement that the two shots were bang bang, one right after the other. Mr. Barnwell was of course operating under the assumption that everything Bell told the police was truthful. We know that it wasn't. He was not being truthful with the police. That was a bad assumption on his part.
Is there testimony that he knew she was in that bedroom
Yes.
from him?
Yes, absolutely. This is their normal routine apparently when they fight.
Not that it was the normal routine, that he actually knew she was there in that room. I thought that there was testimony that he went into the room before, into his bedroom before she went into her bedroom, and how would he know that she was there?
No, he knew she was in her bedroom. He was there, they were fighting, she went into her bedroom, he was aware that she was going in there.
Well, and we're asking what the evidence is.
Right, what the evidence?
I'm sorry, I don't mean to be a smart aleck with you, but I'm just asking what the evidence is.
He testified that he knew she was in there.
Okay.
Absolutely did.
See, I thought he said he assumed she was in there,
No,
because that was her usual routine.
no, he,
All right, then the next question I would have is, given that testimony, was there testimony that he knew specifically where she was, in the bathroom as opposed to the connected bedroom?
no, I don't think there's, no, not that he knew exactly where she was in there.
Is that important in our analysis, if he's shooting a gun into towards the floor and a wall?
Well, one is, as I said, the bullet enters 3 feet off the ground, so it wasn't exactly at the floor. Another one is much higher than that, 5 feet off the ground. So,
I mean, there has to be an intent to cause harm. He didn't go into that bedroom, leave his room and go into the room where she was at to fire a gun.
no, he didn't do that, but he shot at the one place that he would have an absolute, very good chance of her being in mortal danger. He fired at that particular wall, which is abutting the room that he knows that she is in. So, and this whole in the line of fire discussion, this Mills case, it's not even clear exactly what that means. It certainly was not defined in Mills what in the line of fire means. What this is and this was actually a death penalty case where there were, I believe, 24 assignments of error, and they dedicated about 2 paragraphs to the part about this felonious assault. This was a felonious assault that took place in a crowded bank in Mills, and there were 2 shots fired at a teller's desk, and the felonious assaults as to the tellers that were right behind the desk were upheld, but then there was a 3rd person off to the side that was completely out of the picture. They vacated that felonious assault because that person, they said, was not, quote, in the line of fire. They weren't setting out any kind of bright line rule for how we evaluate felonious assault cases. It really is a totality of the circumstances. You have to look at every case individually.
So counsel, let me ask you a question. As you know, obviously, we look at the facts of the case because they're arguing, I should say, sufficiency and manifest weight. However, we also, as a court of appeals, have to look at the precedents that our ruling will have on all the cases that appear. you saying that anytime somebody shoots into a room, that's going to constitute felonious assault?
I think you have to look at the totality of the circumstances in every case, and you can't just, again, that would be like a bright line rule, right? Whenever you fire into a room that you know somebody is in with a gun, then from the other side of the wall, then that's felonious assault. No, I think you have to look at the entire context of the case in terms of the evidence. He's lying to police. He's not being honest about what happened. What he is being honest about is that there's a big fight, and he's in a rage when he does this. And
Yeah,
in terms of
the
the-
devil's advocate, though, there's no evidence that he aimed the gun at the victim. There's no evidence that she was in the path of the bullet that was fired. There's no evidence that he pointed the gun at the victim. There's arguments both ways on this case.
well, and I think the idea that these shots were bang bang also is belied by a lot of the evidence. The state of Ohio obviously disagrees strongly with that notion that this was just a bang bang situation. Carolyn's statement to the police on the night, she describes hearing one shot, then having time to lock her bedroom door, go into the bathroom, hunker down in the tub, and call the police before hearing an additional shot. Then she hears an additional shot.
Well,
So-
I think her testimony was that after she went into the tub, that she heard what she thought were other gunshots, plural.
Additional shots, that's right.
But we know that only 2 shots were fired.
But yes, so, but the idea that this was just an accident and this was not intentional to shoot at her, I think is belied by this idea that there is one shot, then there is a significant pause that allows her to do several things, and then she hears another shot.
Well, the son said that he only heard 1 shot though, right?
Correct.
Was that his testimony?
Correct.
Did she ever testify, did she ever say to the police, I thought he was trying to kill me? I thought he was trying to shoot me?
She did not say those words.
She said, I panicked because I was traumatized and I didn't know if he had, quote, snapped.
Correct.
Okay, those are the words she used?
She said she was traumatized when she heard the shot. She believes he snapped and that he shot his gun out of anger. She was scared and did not know what his state of mind was at the time.
She maybe could have been trying to, did she testify she thought he may have tried to shoot himself, or she did not?
No.
But didn't she testify that he had made threats to shoot himself before?
I believe she may have said that. That whole idea, though, that he was going to do that only came up for the first time at trial. I think that's interesting, and he never said anything about that to the police, that was his intent when he picked up that gun in the first place, and so that kind of just materialized at trial. In terms of the ineffective assistance, just very briefly in my less than a minute, he questions things like the number of questions his counsel asked his expert. Of course, we know that there's no specific number of questions you have to ask to be effective. It's the substance of the questions and the answers obtained in response. Brevity is often the best trial strategy, both in questioning witnesses and in arguments. The decision whether to call a witness at all is classic trial strategy. So
Counsel, I know you don't have much time, let me just interrupt you. Do you recall, and obviously we'll go over the transcript and fine tooth comb, but I want to just ask you if you recall, obviously the mens rea is knowingly. Was that an argument that counsel at trial made, that this was not knowingly, and here are the reasons why?
Before you answer that, thank you for that question, Judge Carr. I'll let you answer this, but you've used your time. Please respond to Judge Carr.
yes, I think that was the that was the big issue at the trial, is what was his state of mind?
Right,
when
but
he
I'm
made these
not
shots?
asking what the big issue was, I was asking what his attorney argued.
Yeah, well, and so so we know that it's knowingly, not purposely. I think that's important to understand, that when a person is aware that a person's conduct will probably cause a certain result or will probably be of a certain nature. A person has knowledge of circumstances when the person is aware that such circumstances probably exist.
Okay,
The state of Ohio proved that in this case.
I understand that. I'm sorry, I don't mean to argue with you. My only question was, what did the attorney argue? Not necessarily what the state presented, but we'll look in the transfer. Thank you very much.
Thank you.
All right, thank you for your argument. Counsel, you will have 3 minutes and 2 seconds.
Thank you, Your
For
Honor.
rebuttal.
In rebuttal, with respect to the prosecutor's argument that Carolyn felt this was much more than stress and what Gary was doing at that time, and asked why would she call 911? Well, why would any person call 911 when in your entire lifetime you haven't been in a house and hear shots fired in your home? That's just a rational response, a human response to hearing a gun go off in your home. I think that's a natural thing for someone to pick up the phone, call 911, go, hey, I heard shots being fired. She knows her husband's the only one that owns a gun, and she comes to the conclusion, hey, Gary's firing a gun. I don't know what's going on, but maybe you guys should come out here. I think that's a natural human response. Doesn't mean she thinks that Gary is trying to kill her. She doesn't know what's going on. She, didn't.
Well, a natural human response may be to call out to your husband, are you okay?
That may be true, Your Honor. Yes, she could have said that too. I will state that as soon as, if you recall the testimony from his son, when he came out of the room, his son came out and looked at him, and he had that shocked look on his face, like, what just happened? What did I do? What just happened? And the first thing he did was run to her room, because he saw the bedroom door was closed, it was locked, and began banging on the door, yelling, honey, are you okay? Are you okay? And he testified, he went back to his room because she said she's calling 911. He knew at that point the police are going to come, they're going to conduct an investigation, they may arrest him, et cetera, et cetera. But that's why she called the police. And I disagree, she testified at trial, she indicated that she knew that her husband wasn't going to hurt her that night, had never harmed her before. And with respect to Gary Bell knowing that she was in that room, at trial the testimony was very clear. He adamantly denied knowing she was in there. He explained it's a habit of hers to go to that bedroom at the end of the night or when she wants to go to bed, but he did not know absolutely for certain she was in that bedroom. And that was clear in his testimony. That's in the transcript. Everyone can read that. I cited pages 153, 154, 157, 159.
But counsel, you also said that after he had shot and his son approached him, he ran immediately to the bedroom. Are you okay? Are you okay? So obviously he knew or was very concerned that she was in the bedroom and he might have harmed her.
Yeah, but Your Honor, the bedroom door was, I don't know if he testified this, I don't know if this came out or not, but the habit was that the door was always open. So when he went to bed first. He saw the door was open. When he comes out after the shooting, he sees the doors closed. Well, he concludes that she was in the bedroom at that time. And that's why he went to the bedroom door. With respect to...
Counsel, you've used your time. I'll give you 30 seconds since I let the prosecutor answer that last question, but just to be fair.
But I think it's a good question, Your Honors, about is it okay to convict somebody just because someone's in a room and they fire 2 shots into a room? And he admitted, no, that's not proof beyond a reasonable doubt. You have to look at the totality of circumstances. I know if you look at the totality of this evidence, there is no evidence at all that Gary Bell exhibited an intent to harm his wife that night. None. 0. It's not in the record. And the overwhelming evidence is this was a stressful shooting. He shot one fire into the wall. Why did he shoot it in the ceiling or somewhere else? Because he's immediately responding to attempting first to shoot himself, and he just pivoted, turned and fired. He was not thinking at that time where the bullet was going at that time. Thank you, Your Honors. And then, on behalf of everyone here, thank you, that's supporting here, thank you.
Thank you both for excellent arguments on this case this morning. We appreciate you also being in person. It's nice to be back, have live in-person arguments. The court's going to take this matter under advisement. We'll issue a decision in due course. The clerk of courts will mail each of you a copy of the decision, as you know, on the day it's released, and the opinions are also posted on the Supreme Court of Ohio's website.